Ebusian for native for need you can so me patch me mobibia aqua baba chani so. Ebusian me patch all. Just some hours ago na Supreme Court of the land no, overturning the ruling of the speaker. That was yesterday. Kaya Babin, the Speaker of Parliament, APA Babonting, Ebema ruling be. Now the ruling was say or declare 4 MPs almost sitting vacant. Now me patrol side way by Emma NPP side no echo Supreme Omoko Court, which is the Supreme Court. Omoko Supreme Court yesterday na with less than 24 hours na Supreme Court na said there be asem no mpeso mudi. Amomudi asem we na speaker ne ruling no. They have overturned the ruling of the speaker. Now me patrol san same way na so far nkofu bebre epiaba bontia be react to. Na former Attorney General bia ye frɛ no Ayikwe Oto on so piaba bontia be react to. Me patrol ban journalist ni bisa ne say inti unhu ni se and or say on it because or not the information or privy to no any according to information on a one on channel on himself in your markings echo apply and I said nani application expertise na expertise ni within 10 days na say court no Supreme Court no mu ruling the kura no was say within 10 days because you can say expert ni for a shorter possible of time one the rest because of ni nature nti no omo mane no so sa nti no na akosoro na 10 days in law sanity na me pacho na sanity dey adinti na Supreme Court apia ba bonten abemo mu ruling ni say until that is like indefinitely somehow until further notice until so mu be wie omo court case no hwe na speaker and declare na say speaker ruling can't be held. Not just say no, it is against even the law because Emrani say expert application kwana say in Janti ubia it should be within 10 days. Me patcho pia ba bonten pa ba react to na owie na Claire to Savoka Zebila MP on so pia ba bonten so ba react to ebusuan we dem say omre ye audio ne yakwa kotintin yen zoom straight na me patcho kame ho na yen ko ti audio no wi anon so won so fa comment e share comment section e budget na yaken kame da se bebre.
There are those who have made the...
I will look at it again, but the order under which they applied, which is the High Court Civil Procedural Rules, allows for ex parte applications, but the orders are only for 10 days because the other side has not been heard. So it will be unfortunate if they did not take the days into consideration. If they did not take that part of the order into consideration, it would have been unfortunate because it is limited, and then you come back and put it on notice.
Which is the argument people are making, and I want to read for you the order by the Supreme Court. What we have on our screen now is not, the first order, which is the execution of the ruling of the Right Honourable Speaker of Parliament Alban Sumana Kingsford Bagbin, dated 17th October 2024, delivered on the floor of Parliament, declaring vacant the seats of the following members of Parliament, is hereby stayed pending the final determination of the suit. Did the Supreme Court err in that?
Yes, if they did say so, then they erred.
I see.
If they did, because the applicants themselves made it clear that they were coming under this order which allows for ex parte applications in the High Court, and usually it is only for 10 days.
Very well. I'll come back to you, Lawyer Ikweotu, but let me move on to, Honorable Avoka at this point. Yes. Honorable, your side has made the case that, listen, the Supreme Court shouldn't have even touched this matter at all because, again, like you said, it's interference of the work of Parliament. But there are those who have made the arguments that, listen, the matter in question itself is a constitutional matter, and hence the Supreme Court should look at it. What's your reaction to that?
Yes, it is a constitutional matter, and the Supreme Court can look at it. But they should look at it soberly and then diligently. If they were to do so diligently, they wouldn't have rushed into saying that the stay is going to stay until the final determination of the case. This is an interlocutory application. This is it is without notice, so the other side is not aware. So they normally take a short date, a short period, like the 10 days that apply requested for. If the Supreme Court was minded to be fair and candid on the matter, because it's a constitutional matter, they would have even given them 1 week or thereabout to be able to come by way of notice and step on the other side so that we'll have the legal arguments or the constitutional arguments. They did not do that. But you are also aware that it is the same Supreme Court. The argument that the 4 MPs, their constituents, will be deprived of their representation and the rest of them, that's a whole water. In the case of James Kesi, Asim North, what happened? Was he a representative of his constituents? And he didn't even cross carpet. It is just that they said that he filed his documents late. I mean, his nationality came in late. Just that. Yet the Supreme Court injuncted him.
I see.
Months. So where's the genuineness in this? It's disingenuous. It is unfortunate that the Supreme Court, the highest court of the land, should be trying to balance issues and bring about something that will keep the nation together, rather than demonstrate this open bias. Sal is there 4 years. They were represented. Where was the Supreme Court? They shouldn't do things that will give wrong interpretation to people. And this is exactly what they have done.
I see. Honorable Avoka, again, people have argued that perhaps your side in Parliament could have chosen a better way to address this, especially when the Constitution tells us in Article 99, when it comes to issues around, the vacancies in Parliament, it should be addressed by the High Court. Perhaps your side could have explored that instead of where we are today.
No, but the method that we also adopted, Article 93 and then 18, etc., not Article clause, orders of the Standing Orders of Parliament, gave the Speaker the right to do what he did. People are referring to Article 99. Yes, I have seen it and I appreciate it. That is one way. But the Article 97 did not expressly state that this is what should be done. And Article 110 or so of the Constitution gives authority, gives the right of Parliament to use their internal mechanisms and internal rules and regulations to be able to arrive at that decision, to be able to solve the matter.
I see.
So it's neither here nor there.
Lawyer Ikweotu, that's the content of Article 99 raised questions about whether or not the Supreme Court has jurisdiction to hear the substantive matter itself.
Yes.
Well,
exactly.
You see...
no, that's for Lawyer Ikweotu.
You see, what we should not forget is that the Constitution by Article 2 and 3 says that any person who alleges that an act of any person is inconsistent with or contrary to the Constitution can always seek an interpretation from the courts. So where a matter of interpretation arises, then the proper place to go will be the Supreme Court. On the other hand, if the issues have already been determined, then you only apply the Constitution like any other law of the land. There's no need for you to go back and seek any interpretation. I give an example once where policemen were compulsorily retired at the age of 55, when the Constitution says that it should, retire at the age of 60. And then I went to court when a client of mine was compulsory retired at the age of 57, not yet 60. And then the friend said, "Are you asking me to interpret the Constitution?" I said, "No, I'm giving you rather a judgment from the Supreme Court which says that once the people are members of the public service of Ghana, they cannot be compulsory retired until they are 60. They said, "Oh, yeah. Then if that's the case, we are just going to apply the law and not to interpret." So where the law has already been interpreted, and you apply. However, in this case, you see that there has been a number of interpretations as to what the provision stands for. So it calls for an interpretation or which means that there's some ambiguity. So anybody can go to the Supreme Court to ask for, interpretation. And for example, if a parliament should pass laws by, for example, a subsidiary legislation should have to lie in parliament for 21 sitting days before it becomes a law. And then you send something there, it does not lie for that 21 days, and parliament says it has come before force. That can be challenged. That is not a procedure.
No, but should the Supreme Court be hearing the substantive case, or it should refer it to the lower court, the High Court?
No, it is a matter of interpretation. It is a matter of interpretation, and they think an issue of interpretation has arisen. They can always, in fact, remember that when there is a matter before a lower court and an issue of interpretation arises, they can refer it to the Supreme Court for interpretation. So unless we have evidence that that particular section or article has already been interpreted, then it's a matter of enforcement. So go to the proper court to go and have it, enforced. But other than that, then the issue of interpretation arises. I don't think Mr. Abuka would disagree.
I see.
There is an issue of interpretation.
Well, but Honorable Avoka disagrees with you. Honorable Avoka, you know, when I posed the question earlier, you said yes, that should be the case. That based on Article 99, the Supreme Court should not have jurisdiction over the substantive matter itself.
I have made a point already to you that if there are issues of interpretation, anytime there is issue of interpretation, even if it's right.
No, lawyer Ikwetu, that's for. I was referring to Honorable Avoka.
Oh, okay. Sorry.
Honorable Avoka, go ahead.
Again to him.
Yes. In my humble view, Article 97, particularly G and H, does not need interpretation. So the provisions are so clear and unambiguous that they can only be declared, like the Speaker did the declaration, the implementation. They don't need interpretation. Article 97 doesn't need Supreme Court interpretation. The provisions are so unambiguous, they are so clear and so straightforward that if you are elected on a particular party ticket and you come to Parliament and you go ahead to file your nomination to contest on a different party's ticket, then you are virtually defected or cross-carpet. And therefore, you need an application to say that you are no more a member of Parliament in the House. It doesn't need any interpretation. It doesn't need the intervention of the Supreme Court. It is not ambiguous.
Very well. Let's talk about some of the nuances that have come along with this ex parte ruling that we've heard from the Supreme Court today. Again, your side have questioned why the Supreme Court swiftly or considered this matter even urgent enough and heard it as swiftly as it did. But the Supreme Court, in its written certified copy reasons that it has written, explains why that is the case. Does it put to bed, Honorable Avoka, the debate as to whether or not the Supreme Court is biased and for that reason it is dealing with this matter so swiftly? Honorable Avoka.
Yeah, I lost you the last minute.
I was asking that your side has questioned how the Supreme Court swiftly listened to this case, swiftly catered to the demands of this case when it hasn't done that with other issues. The Supreme Court, in its written ruling, explains why this matter is urgent. Does it put to rest the debate as to whether or not the Supreme Court is biased in favor of the ruling party?
Or the Supreme Court has the ability and then the authority to urge parties to hasten up application of matters in the Supreme Court. They can give directives to the registrar to make sure the parties file their documents within a certain stipulated time so that the case can be handled. And that is very simple. Why didn't we bring that to the other cases that are also very important? That is where the issue of disingenuity comes in.
I see. Lawyer Ikwetu, I do want to also find out from you, when the Supreme Court talks about the gravity of the issue for which reason it meets or it hears this ex parte motion, in his court, but at the same time, the person at the question of this issue, this grave issue that the Supreme Court applied some urgency to, has not been heard from. So what is the evidence that the Supreme Court relies on to be able to come to the conclusions it did in its written ruling?
Well, I believe they were all contained in the affidavit. The applicant swore an affidavit showing the urgency of the matter and the gravity of the matter. What would happen if a stay is not given? I have said elsewhere, I think the NDC were not strategic in their moves. They were talking too much and giving too much away of all the things that they wanted to do. If you do that kind of thing, you ask the other people to sit well. And so they invited all these things onto themselves, making the people rush to go and look for in order to stop what their intentions are. Now, if we say, for example, you are going to review the e-levy, the e-levy is part of the budget and the appropriations bill. If you do that, what's going to happen to funds that are allocated, or projects that are allocated through funds that will be collected from the
well,
you're going to create confusion. You are going to reorganize all the committees of parliament, and all kinds of things that they were throwing about, were a little frightening. And that's why I say gravity of the matter and the urgency. And so you don't have to compare what has happened to whatever has been the case. For example, let's go straight to the LGBTQ. That one, there was no ex parte application. In this case, here is an ex parte application which must be heard.
Right. So
once you file it, it should be heard. It's
very
different
well.
from a normal application on notice.
Lawyer, I'll move on to Honorable Avocat. We'll wrap up this conversation. What's next for your side now that this ruling has come into play?
Well, before I come there, let me allude to what my very good friend, Mr. Otu, have just said. He talked about the excitement of the NDC, the utterances they made. They have become the majority side to repeat e-levy or reduce the perception rate of that. Is this a matter before the Supreme Court? This is not an issue before the Supreme Court. So it's irrelevant, with the greatest respect. And if you look at the conduct of the majority leader, this is a hung parliament. You get a ruling from the Supreme Court. If you think that the NDC are very excited and therefore that prompts you to go to the Supreme Court, the attitude of the majority leader, Akroma Markins, his body language, his utterances, is not conciliatory. It doesn't build a consensus as far as Parliament is concerned.
What's next?
That's what you have said, the question you have raised. We just had the ruling today. Parliament hasn't met as a body. I mean, our caucus hasn't met as a body. Our leadership has scattered all over, including MP.
Abusafonete for me patcho me da obi bia sesa wa Genral no akoti audio no so. Me patcho wo comment anything. What is your opinion? Supreme Court and why idea like why the right thing? And now say idea Supreme Court no why no so no enye the right thing. Because according to Likee Otun or say the Supreme Court erred. Na you say omo ye mistake. Enye kwan person omo fa so ye omo nyuma no. When do I say it? Because of the ex parte nature of the application no, mutimi hwe intentem. Inti mo hwe intentem so na say mo overturning the ruling there. It should be within 10 days because na sa within 10 days no na after all mo free mo say within 10 days na mo be dey mo be to a case ni so. Inti sa dia within 10 days no speaker ni ruling no ma overturning. Na ma overturning a mo so mo overturning no mo say till say mo be dey mo be di asem na wie. Na edi ntina eye ex parte application. Wadwen kire wo sen. Me patcho fa comment share comment section. Ye beje ni akenkan. We stand to be corrected and we stand to learn. if you have any idea be an answer we are expert in law, you can also educate us more. Nyankopon sha no nya okese medase bebre.